Part heard appeal in the matter of the Financial Conduct Authority and BlueCrest Capital Management UK LLP.
Mr. George, Mr. Herberg, everybody. I'm sorry to have messed you around a little in relation to sitting times, but I'm afraid I am going to have to rise promptly by 2:15. Since the message I had sent you, it's occurred to us that it might be more sensible to have a bit longer in the afternoon session and to perhaps stop at 12:45 and start again at 1:30, if that's satisfactory to the parties.
We're very grateful.
All right, we'll do that. Thank you very much.
My lords, my lady, I will deal this morning, if I may, firstly with some observations on some points made by my learned friend on the tribunal in relation to the jurisdiction of the tribunal on the amendment issue. Second, to say something about the various cross appeals. And thirdly, to answer questions which this court gave yesterday, which I will do in brief form. But my lord, to deal with the first of those points and to continue from where we left off yesterday, one of the points taken and emphasised by the tribunal relates to the nature and purpose of the statutory notice procedure in FSMA that we looked at yesterday. And what has been said against me is that this requires that as we move from warning notice to decision notice and then to statement of case in the tribunal, that the allegations stay the same, because that is the only way to make the procedure fair and indeed to make sense of it. But in our respectful submission, that is not right. If I could invite the court's attention to page 146 again of the authorities bundle, volume 1, tab 4.
Section
387. I apologise, my lord, I forgot that.
Well, I've got some of them separately. And
I understand, my lord, no, that's my fault. You said so yesterday. And section 1C of 387 1C requires that a warning notice must give reasons for the proposed action. But in our respectful submission, that the purpose of that requirement is entirely explained by subsection 2, and the fact that a warning notice must specify a reasonable period within which the person to whom it is given may make representations to the regulator concerned. There would be little value in a right to make representations if you didn't know the reasons why the decision that was proposed to be made in the warning notice was proposed to be made. But once you have a contested representations procedure, an inter partes procedure, it is clearly foreseeable, and in many cases will be extremely likely, that because representations have been made, new facts have been put forward that maybe the regulator either wasn't aware of or now accepts and didn't before, that maybe the regulator takes a different view, or indeed the regulator relies on other facts or other matters which they say changes the situation. That is inevitable, effectively, in a contested procedure. And it would be extremely surprising if effectively, despite having an express representations procedure, the statute proceeded on an all or nothing basis, i.e. either the decision notice drops the allegation or it accepts it in its original form. And the same logic in my submission applies to the mirroring provisions at 388 1b or page 148 in relation to decision notices. There is the same right to give, the same obligation to give reasons, and in this case, of course, as we see, there is a right to refer to the tribunal. But in my submission, the same logic applies. The tribunal will obviously have a much wider remit to consider facts. It will make its own findings of fact, and it may well make different findings for different reasons to those put forward by the regulator. There is no reason why this procedure in any way supports the idea that the tribunal's jurisdiction is limited in the way that has been contended. The reason that you need reasons is so you can make representations at each stage, not because the reasons must stay the same from warning notice to decision notice to statement of case. And the second point I wish to address, my lords, my lady, was this. In their skeleton arguments, BlueCrest's primary case on construction is a proposition that's not contained within the Upper Tribunal's reasoning, but is effectively that the meaning of the word matter differs depending upon the type of case you are looking at. So it is posited that in a case that is looking to the future, is someone fit and proper? Does a firm meet the threshold conditions for authorisation? You have a wider, it seems from their skeleton argument, unfettered ability on the part of the tribunal to permit anything that would go to those extremely wide questions. But, they say, not so where the matter or the issue is a redress scheme imposed for a past breach or a disciplinary case looking at a particular act of misconduct. And my lord, my lady, we can obviously see why that suits the case that they wish to advance, because they are only concerned today with a disciplinary case based on a redress scheme based on an act in the past and a disciplinary case based on misconduct in the past. But in our submission, it has no support in logic or principle that there would be this bifurcation, this change as to the tribunal's jurisdiction, in the one case it being effectively without any edges at all, in the other incredibly narrow. Because as a point of principle, the developments during the course of a contested procedure where both sides are making representations or in the tribunal putting forward evidence are just as likely to lead to developments which require to be taken into account either by the regulator or by the tribunal, as they are in a case that deals with fitness and propriety. And we looked yesterday at the case in Burdett, which gives rise to this very problem, a disciplinary case, in part, where different facts could emerge that makes it appropriate, at least in the tribunal's mind and findings, to characterise a case that was originally put forward as one involving a lack of integrity, as one involving a lack of care, skill or diligence, or a failure of systems and controls. As I submitted yesterday, there is no reason in policy why such an amendment should be precluded in a disciplinary case. But any logic or policy support that my learned friend seeks to garner from his argument, in my submission collapses once he accepts that in many cases, those that are future-looking, you can bring in new allegations. If BlueCrest's point, and my learned friend's point, is that the hard edge represents the necessities of justice, it's an inviolable point of principle, it's required for procedural fairness. If that is his case, then that must be required for all cases, whether they are disciplinary or non-disciplinary. You cannot have in my submission a so-called inviolable principle that simply melts away in some cases, but not others. And the practical meaninglessness of the distinction that is sought to be advanced in my submission becomes clear when one looks practically at the nature of the majority of cases which come before the tribunal, or indeed that the regulator decides. They tend to involve both either a prohibition or a withdrawal of approval, a non-disciplinary sanction, and a disciplinary fine for misconduct. Because the reality is that although it's right to say that a test can be, is somebody fit and proper today, the reality is that all prohibition cases involve an allegation that you have done something in the past which demonstrates that lack of integrity. They are based on incidents that have occurred in the past. There is no substantive distinction in what occurs between a disciplinary and non-disciplinary case based on that type of incident. What you do have, of course, occasionally are allegations that are only or could only have been discovered later, or allegations that are arrive later, such as Mr. Hobbs lying to the tribunal. But there is no good reason why they should fall out with the jurisdiction of the tribunal in either a disciplinary or a non-disciplinary case. And as I submitted yesterday, of course, any prejudice, any unfairness in that jurisdictional threshold can be corrected by the tribunal applying its case management powers. And when we look at this case in my respectful submission, the difficulties of this distinction between is it forward-looking, is it backward-looking, become particularly clear. So if one looks at section 55L, which is at page 59 of the bundle, of the authorities bundle, the power to impose a requirement, The trigger conditions, as we saw yesterday, set out in subsection 2. Subsection A is failing or is likely to fail to satisfy the threshold conditions for which the FCA is responsible. So that could be an allegation of past conduct, you have failed and you are failing today, or an allegation as to future conduct, you are likely to fail, all within the same subsection. And of course, in many cases it could be both. B is past looking. And then C, it is desirable to exercise the power in order to advance one or more of the FCA's operational objectives. Again, could be triggered because of what has happened in the past. That means that it is necessary to take action, or what might happen in the future. There is no distinction in the statutory language that supports that which my learned friend has put forward.
Well, it might be said that they're all forward-looking in a sense, in that they are conditions to continued permission to practice, and in one sense might be characterised as conditions as to whether you remain a fit and proper person.
My lord, I respectfully endorse and adopt that, and it was the next point I was going to make, was that one couldn't imagine that this case itself could have been framed on the basis that BlueCrest would be likely to fail the threshold conditions, in that it would not be fit and proper to carry on regulated business in the future unless it properly compensated clients for what had occurred in the past. And that would be to recharacterise my backward-looking case as a forward-looking case. And in my submission, it would be absurd if the hard edges of the tribunal's jurisdiction depended on this type of semantic distinction. So, my lord, we say that the answer is not to be found in effectively a submission that whatever the jurisdiction is, it's narrow for these two type of cases that we're concerned with today. It has to be a coherent and consistent rationale across the scheme. Did my lords and my lady receive the transcript from last night? May I just briefly, my lord Justice Popplewell helpfully set out a waterfall of issues and asked whether they, and it's on page 189 of the transcript, as to whether they all fall within my primary case, and it's at page 189, line 5. And if I may, I'll just, now having had the benefit of the transcript, just endorse what I said yesterday. Yes, they do. But in terms of looking at a waterfall, it is, in my respectful submission, extremely helpful to look at these four categories. My lord sees one, the decision, imposition of the penalty, and therefore allows whatever the reasons that were given for it, and allows any other reasons to be advanced for the same penalty, and I would add, or outcome, such as a redress scheme. And my lord, yes, we say that in fact is this case. We are, to the extent they are different, advancing slightly different reasons for exactly the same decision. In example 2, my lord posited any of the facts and matters which were relied on for the decision, even if you were seeking a different decision in the tribunal. So my lord's first point was different reasons, same decision. My lord's second example is same reasons, different decision. And again, yes, in my submission, that clearly must fall within a sensible jurisdiction. And I give the example of where a tribunal accepts all of the facts that have been pleaded. There are no changes and no amendments at all, but it decides as a matter of sentencing, if I can use that word, that a financial penalty is too harsh and a public censure is appropriate. That would be an example of my lord's second category. My lord's third category was any of the facts and matters that could have been relied on in reaching the decision but weren't. And I apprehend what my lord perhaps had in mind there was those that were in play. So they are not part of the decision that is reached, but they were raised by one or other side as part of the debate. And that is a line of reasoning that, of course, we see in Jarbret, particularly because of how that came out, and it's commended itself in other cases. So as a waterfall, it's helpful to then say, if you want, as my lord says there, a different decision for different reasons, is it required that you have matters that were in play? Is that the limits of jurisdiction? And that's a Jarbret type case, because in Jarbret, a different reason, lack of integrity, not lack of reasonable care and skill, was relied upon by the FCA to invite the tribunal to reach a different decision, namely prohibition, rather than simply withdrawal of a particular type of approval. And obviously the slight oddity in my submission we've reached is that although that was allowed in Jarbray, the line of Jarbray authorities has now come round to effectively, as a result of the BlueCrest decision, prohibiting that which was allowed in Jarbray. And then the fourth point, my lord, and obviously these are getting further away from the original decision as we go, which is why they're very helpful as a waterfall. You say any facts or matters, whether or not they could have been relied on, so that in theory there is no jurisdictional bar on seeking a different decision on different grounds in relation to facts that were not in play, if I can use my shorthand, either because they just weren't raised or because perhaps they didn't exist. And yes, my lord, in relation to that fourth category, I also say that is within jurisdiction, although I quite see in many, many of those cases, case management powers will be used not to permit the case to proceed. But to give one example, let us take a Hobbs situation where somebody is found to have lied to the tribunal, but the original sanction was merely to withdraw their approval as a senior manager. And the tribunal considers, in the light of the fact that they maintained a false case under oath in the tribunal, a prohibition is appropriate. That would be a situation with different facts, ones that were not in play and different reasons. But I say in that situation, any sensible jurisdictional system should permit the amendment. And obviously it is only permissive because of the tribunal's case management powers.
I should perhaps then have put a fifth category, which is completely different reasons for a completely different decision on completely new facts.
Yes, my lord.
And I think you do say, even at that, in that widest sense, there are no edges.
Well, I suppose one might say in the fifth reason, completely different facts, completely different decision, not in play at any time, and no good reason, i.e. they only came about later, why you couldn't have done it. Effectively, the widest possible change of case. And yes, on my jurisdictional analysis, and I say this is how Granada analyses it, there is still not the jurisdictional bar, but I wouldn't expect that to be allowed as a result of case management, any more than anything else that was plainly not acceptable. And of course, that's how, as we saw in the Hansard debate, in a sense, the balance needs to be struck. And in my submission, it's struck by the tribunal having case management powers rather than jurisdictional hard-edged limits. So, my lords, my lady, that is what I say in relation to the jurisdiction on the amendment section of the appeal.
And what may be said against you in that widest sense is that you are then treating the matter that can be referred to the tribunal as something which has absolutely no connection at all with the process that has gone before.
I accept that, and I mean, my submission is that is the way this statutory scheme was constructed, because we can see it has these hard-edged limits about different parts, and we can see that that was the reasoning in Granada. But I also posit, as this court is aware, if that doesn't find favour, you've seen the formulation of the matter at paragraph 95, which effectively, and that's why the waterfall is very helpful, because in my submission, 1, 2, 3, and 4 in the example I give clearly fall within the matter concerned when you interpret it in the way that I have set out at paragraph 95. In your fifth example, my lord, where I have absolutely no connection factually, legally, or outcome-based with the original decision, I can see the argument, well, that's where the matter comes into play. And, you know, I advanced the primary and secondary cases because I recognise that the possibility that the right answer is that the matter needs to be given a meaning, but for the reasons I have given, I submit it as much wider than the tribunal has held within these cases, going through the waterfall that my lord has outlined.
Thank you.
My lord, I turn to the cross appeal, and I will deal with these more briefly, because in many ways my submission is the tribunal was right for the reasons they give. But let me, if I may, identify what is in play so that we know. May I start with the second contested amendment? We looked at it yesterday, but obviously haven't really addressed it since. But it's back in the supplementary authorities bundle, supplementary bundle, tab 17, page 585. court will recall, we succeeded on this below. It's a Prin 8 case. It doesn't involve any relabelling. All it does is explain why the external investors themselves were clients. And you'll recall our cases, we'd always pleaded they were clients. See paragraph 42 of the unamended version. This was merely particularising why they were clients. And the first point taken on the cross appeal is there is no jurisdiction to permit even this type of amendment. And obviously I won't repeat my submissions because this is even narrower than the tribunal has reached, and for all the reasons that I set out, that would be the wrong construction of a jurisdiction. But there is one particular point we rely upon, that whatever the jurisdiction is, this is not just something that has always been in play, it's something that's always been in the pleading and in the decision notice. It's simply being reordered in a more felicitous basis. And I will very briefly, if I may, just take you through some fairly quick but slightly detailed documents just to show and make that point good. It's all set out in the reply skeleton, paragraph 63 at page 228, but it may be worth just looking at the documents. So we start at supplementary bundle, page 25. Tab 5. This is a draft warning, this is a draft annotated warning notice. So during the pre-notice stage, the subject of investigation receives, it used to be an investigation report, but now it's effectively a draft notice with endnotes that explain the reasoning, and basically the parties then negotiate and either reach a settlement or they don't. And so this is what was in play prior to the notice procedure. And does my lord see and my lady see paragraphs 421 to 424? It's at page 25 of tab 5. So this explains in the draft annotated warning notice why first the external fund was a client. You see that at 421 and 422. That is unchanged in the decision notice and in the warning notice and the statement of case before the tribunal. And you'll see at 423, in addition, pursuant to the DA, the investment manager appoints BlueCrest to be sales agent on behalf of the funds. BlueCrest's responsibilities as sales agent were set out in the MSA with the investment manager. In respect of these services, the external fund, the internal fund, and the fund's underlying investors were classified as clients by BCM UK. So 421 and 422 pleads the why the external fund was a client. It's because they actually had a contractual relationship. 423 pleads why the external fund's investors were clients, and 424 sets it all out. And do you see, my lord, my lady, the reference to endnote 64? And that is at page 62. And it is a little bit small print, but does my lord see, as per the definition of client given in Cobbs 321R during the relevant period, and the court may recall we looked at that yesterday, and that is what I call the deemed regulatory provisions, because they were arranging deals and investments, because they were sending out financial promotion materials, they are deemed clients. That's what we said in this draft warning notice, annotated warning notice, with this very helpful end note. This is responded to in this negotiation period or contested representations period at page.
Sorry to slow you down, but Principle 8 also refers to customers.
Yes.
Am I right in thinking that the definition is, for present purposes, the same as client?
For present purposes,
not universally, but
not
for
universally. There's a
purposes.
category of client called an eligible counterparty.
Yes.
That is not a customer.
But that doesn't matter for
That
our
doesn't
purposes.
matter. The fact you'll see back in page.
Don't worry, unless Mr. Herberg
It does,
tells me
it's
that
common
that's
ground, exactly. Because they were professional clients, they're both clients and customers.
What is an eligible counterparty?
It's an extremely large institution. I remember in a case between the Libyan Investment Authority and Goldman Sachs, the Libyan Investment Authority were prima facie an eligible counterparty because they were a sovereign wealth hedge fund. It's that type of institution. I think there was then a debate about whether, given the relative naivety of the Libyan Investment Authority, that was right or not. But it's that type. So where you have face-to-face trading between wholesale banks on their own proprietary basis, they will normally treat each other as eligible counterparties. But it doesn't arise in this case where we have investors investing in a fund.
And when you say professional client, these are not retail funds.
Precisely. That's the threefold distinction. Retail clients, professional clients, both are customers, and then an eligible counterparty who is out with the customer but is still a client.
Thank you.
So this is what comes back at page 139. So there's a very detailed response to the whole matter. Paragraph 424 is misleading as clients themselves self-identified as either professional clients or opted up to professional client status. This includes the individuals with exposure to the internal fund. This paragraph would be more accurate if the FCA referred in the text to the relevant handbook rules or definitions being relied upon. So the point being made is not we're not clients or the external investors are not clients, but effectively we didn't make them clients, we didn't ask for them to be clients. It's a regulatory deeming provision, and that's common ground as well. Now, and I make this next submission and I accept it is a mistake, and it's a mistake in the drafting when the warning notice was issued. But if we go to Supplementary Bundle tab 10, page 379, everything you have just seen from the draft annotated warning notice, this sounds a bit like Morecambe and Wise, remains in the document, but just not necessarily in the right place. And I accept that. So if we have a look at paragraph, page 379, 421 to 424, I don't have endnote 64 because that's the way the FCA operates. They take the endnotes out when they just issue the notice, which can create problems when important information gets lost. And you'll see here at 421 to 424, we have the same paragraphs relating to the external fund being appointed and therefore being a client, and that's not controversial. You recall the amendment to that was consented to. And in my favour at 424, I still have the statement, and I say this is just about enough, that the underlying investors had professional client status. So it's pleaded in the decision notice, it's pleaded in the statement of case, that the underlying investors had professional client status.
This is the warning notice.
Precisely, this is the warning notice, and these paragraphs track right the way through to the decision notice and the statement of case. The mistake occurs at this stage. So I've got that at 424, and this is my unamended statement of case at paragraph 42 is exactly the same.
Yes.
The external fund investors were clients, and I say that's enough for my purposes. But it's not what would have been ideal, because if one goes to paragraph 4.61, here is and that's on page 387, here is the paragraph that used to be before 424. Pursuant to the master sales agent, BCM UK was appointed by the investment manager to market and sell subscriptions for investment in the external fund. This included BCM UK providing presentations and issuing marketing materials to prospective investors in the external fund. These responsibilities were primarily carried out by BCM UK's sales and marketing team. That's why the underlying investors are clients. And in the draft annotated warning notice, they were all in one section, and you could see they were all relevant to the issue of why they were clients. I can't put forward an explanation beyond somebody during the drafting stage clearly thought it would be helpful to move this master sales agreement paragraph to where it sat more naturally in the flow of the narrative next to all of the things that were issued as a result of the master sales agreement. But the result was it became divorced from its original primary purpose, which was to explain why the underlying investors were clients. So what are we asking to do by the second amendment, and we now see this at tab 17, page 584. My Lord sees in paragraph 41A, we simply put back that paragraph where it originally was. And we're not saying anything that isn't in paragraph 81, we're simply putting it back where it used to be, so that the word in respect of these services in 42 now clearly relates to both of them. And then if you look at F and G, that simply sets out what used to be in EndNote 64. So my second contested amendment, I say, is strictly unnecessary in the sense that despite the error in moving the paragraph, I still just about have enough on my unamended case because of paragraph 42 and the way that tracks through. I say they were clients. That's enough, even if I haven't particularized why they were clients. But I obviously accept it's better to have a particulars in the right place, and so all the second contested amendment does is put it back in the right place, that this is why they were clients. But on any view, and the reason I make that rather laborious tour is because if it commends itself to this court that what matters is were the allegations in play at an earlier stage, these definitely were, which means that the jurisdictional challenge that my learned friend makes to my second contested amendment becomes particularly difficult and, in my submission, unsurmountable. So that's my learned friend's jurisdictional challenge to my second contested amendment. He also challenges the exercise of the discretion of the tribunal in my favour when it found, having found it had jurisdiction, that it decided to permit the amendment. And there is a detailed passage, paragraphs 152 to 162 of the judgment, page 266 of the core bundle, where the tribunal analysed this issue. May I first say something briefly about the relevant test to apply when this court is considering an appeal from the Upper Tribunal on a challenge to the exercise of the discretion. At our reply skeleton, paragraph 61, which is page 228 of the core bundle, we set out some helpful observations made in a case called ABP Technology, and that is at page 1609 of the authorities bundle, tab 58. And it may be worth turning that up.
1609.
And my lord sees the sidelines paragraph at 21. Principles applied on appeal from the exercise of discretion have been addressed in many cases. I would only refer to the useful summary by Mr. Justice Saini and Azam. An appellate court will only interfere with a discretionary evaluation where an appellant can identify one or more of the following errors, and the court will see, and perhaps the court is willing to read paragraphs 51 and 52. That's what we said in our reply skeleton, but we believe we may have been wrong in some respects about that, because it doesn't take account of the fact that a right of appeal from a tribunal is only available on a point of law. And if I may, my lord yesterday invited us to provide copies of certain authorities in our skeleton, but not in the bundle. So these are not new authorities I'm about to hand up in this bundle. They're simply ones referred to yesterday, but not in the bundle. If I could just ask Mr. Rattan to set them up. So you have here some cases referred to yesterday from our skeleton argument, going right back to the redress point. But what I would just wish to draw attention to here is in tab 2, you'll see Tribunals, Courts and Enforcement Act 2000, section 13. For the purpose of subsection 2, the reference to a right of appeal is to a right of appeal to the relevant appellate court on any point of law arising from a decision made by the Upper Tribunal. And that brings into play a somewhat higher test than in the standard matters. And the classic statement of what an appeal of law is, or a point of law, is in Edwards and Bairstow from the House of Lords in 1956, and that's at tab 4 of this bundle, and page 31 contains the statement. So just 2 lines above the perhaps one picks up at the bottom of page 30. So if a party to a hearing before commissioners expresses dissatisfaction with their determination as being erroneous in point of law, it is for them to state a case, and in the body of it to set out the facts that they have found as well as their determination. The point about inferences. When the case comes before the court, it is its duty to examine the determination having regard to its knowledge of the relevant law. If the case contains anything ex facie, which is bad law, and which bears upon the determination, it is obviously erroneous in point of law. But without any such misconception appearing ex facie, it may be that the facts found are such that no person acting judicially and properly instructed as to the relevant law could have come to the determination under appeal. In those circumstances, too, the court must intervene. It has no option but to assume that there has been some misconception of the law and that this has been responsible for the determination. So there, too, there has been an error in point of law. I do not think that it much matters whether this state of affairs is described as one in which there is no evidence to support the determination, or as one in which the evidence is inconsistent with and contradictory of the determination, or as one in which the true and only reasonable conclusion contradicts the determination. Rightly understood, each propounds the same test. For my part, I prefer the last of the 3. So, my lords, my lady, my respect.
Edwards and Bairstow is a very familiar case for tax appeals, where really they're either facts or questions of law, but this is rather different because this is the exercise of a discretion. What's the test for an exercise of discretion?
In my respectful submission, and there is not direct authority that permits of only one answer, and I choose my words carefully because of certain matters going on at the moment. But certainly, the question of what a point of law is addressed in Edwards and Bairstow, we are dealing with here, and I appreciate that there are questions of fact, but effectively this is an evaluative exercise, the exercise of a discretion, evaluating and giving weight to competing matters.
I would agree with what my lord says. Edwards and Bairstow is relevant where you're looking at questions of fact and appeals on fact. I would be quite surprised, speaking for myself, if the test you've just taken to the same, Mr. Justice Soney's summary, is the incorrect test in this context as well.
Well, my lord, my lady, let me leave that there, if I may, because I show it to you. But as I say, we have a reply skeleton puts forward that test from Mr. Justice Soney. It's one I'm very happy to rely upon and indeed adopted.
I suspect if one looked at case management appeals from the tribunals, those sorts of tests in practice.
My lord, my lords, my lady, yes. Either way, in my respectful submission, we have here a discretion that is exercised for a number of clearly set out reasons that are unimpeachable. This cannot be said to be out with the reasonable exercise of the tribunal's discretion. There was no suggestion the amendment was bad in law. That point's not taken. There's no suggestion it's unclear. And it's made at an early stage of these proceedings. And obviously, those proceedings have not even had a trial being listed. And so in my respect, and it merely clarifies what I say is inherent in the pleading anyway, and was certainly always was set out more clearly in the documents during the earlier negotiation stage. It's certainly in play. So in my respectful submission, that is there is no sensible challenge. So, my lord, my lady, I then move on to the cross appeal on the third and fourth contested amendments. You'll recall I've lost on jurisdiction on this one, but my learned friend invites you to, and the tribunal did not exercise any discretion or explain how they would have exercised any discretion had they found it to be within jurisdiction. And of course, in many cases, if the court found for me jurisdiction, it may remit it. And we've seen that in a number of cases, including Granada. But my learned friend asks you to exercise your own discretion to refuse to permit the third and fourth contested amendments, even if you find there is jurisdiction. And we would say that would be quite wrong for this appeal court to do.
Do we have to, we've got power to do it under the Tribunal's Courts Enforcement Act?
My lord, I'll wait to see how my learned friend develops it, because I cannot immediately see the basis upon which this court, it's not substituting discretion, it's simply exercising something that hasn't been done.
If we set aside the decision on the basis of that the tribunal was wrong on jurisdiction, we can, under the Act, remake the decision, or we can remit it. So you would need to persuade us that it is appropriate. We would need to be persuaded that it is appropriate for us to remake it.
Precisely.
And you're not inviting us to on your case, or are you? I had, certainly in your skeleton, I thought you were.
Well, if this court considers the appropriate matter is to remit, because it's a specialist and expert tribunal, I accept that that is a matter this court may well find, and I'm not suggesting otherwise. If, on the other hand, this court says, actually, no, we found there is jurisdiction, we are going to make this decision, and as to whether or not to exercise the discretion, we submit that should be exercised in our favour.
And under subsection 6, is it, or 6A, for the purposes of the redress notice, that's a finding we can make, is it, that we direct the tribunal to implement? And may not have used the right language, but
Well, as an appeal court, you would be remaking the decision of the tribunal, so it wouldn't be a FSMA decision, as it were. You wouldn't be directing the authority to do anything. You would simply be sitting as an appeal court over the Upper Tribunal and setting aside its order and effectively remaking it, which my Lady Justice Falk has.
I'm sorry,
is a matter available, but not necessarily the right course. But the relevant points here are that
Sorry, I'm now not quite sure. I understand entirely. You say that it's that either we should remit it or we should decide it in your favour. We shouldn't decide it against you. I understand that's your position. But do you have a preference, if we get to that stage, between remitting it or deciding it?
I've counted the votes, my lord. We would prefer that this Court of Appeal makes the decision. This matter has been going on for a long time, and we are confident this court has all of the relevant facts and matters before it.
Well, if you want to revisit that when you've had a little longer to take the poll and get proper instructions,
You'd like to
you
revisit
may.
this when you see the judgment, but you're not
No.
offering this opportunity.
But it is something you ought to be
Yes,
advancing on instructions. So if you need
Precisely.
to get clearer instructions, you can have a locus penitentiae to change your mind on that before the end of the
I'm very grateful,
hearing.
my lord, and we'll explain that before the end of this hearing and to reach a final position. But what you do know here is how the tribunal exercises discretion on the second contested amendment. And you can see that at paragraphs 152 to 162. And for all of the same reasons, I submit that whoever makes the final decision, be it you or the tribunal, should clearly permit the third and fourth contested amendments. Again, there is no suggestion they are bad in law, no point of that sort is taken. There's no suggestion they are unclear. And for reasons I have set out and won't respond, it is, we say, a case of relabeling, and it is a point properly taken in response to an allegation made against us in relation to the actionability criteria on the redress.
For your benefit, I think section 14(2) of the Tribunal's Courts and Enforcement Act empowers the relevant appellate court, which is us, if we set aside the decision, either to remit it or to remake the decision.
I'm extremely grateful to this court for both the principle and the source. The only final matter on the third and fourth contested amendment is just to tie it back into redress. It is my submission that even if you're against me on the redress arguments and the actionability criteria, that if I am permitted the fourth, it's actually the fourth contested amendment that matters here, I now have an actionable cause of action, and that's not contested. And I say that I then have a properly pleaded case that satisfies all four criteria. There's a point taken against me that we haven't sufficiently pleaded causation, but it's a point that is run really, it has the same point regarding the original Principle 8 allegation as it's raised in relation to the new one. The pleading is at paragraph 173. So in my submission, if that amendment is allowed, then we succeed on all four of the criteria, even if you're against me on whether they should be allowed in.
You said, I think, if I remember correctly yesterday, quite frankly, that it was a response to the suggestion that jurisdiction required actionability. Is it an amendment that you would press if we were to find in your favour?
My Lord, yes.
On the jurisdiction?
My Lord, yes. Having raised it and seeing now how the landscape will develop in terms of arguments at causation about prospective investors and investors and the time at which they were not informed, we would wish, if you would permit it, to be able to go to trial with the full gamut of chronological allegations and status allegations, i.e. before people make the decision and after they make the decision. My Lord, so yes.
Thank you.
My Lord, the final part of the cross appeal, and obviously I'm now going back to the redress allegations yesterday, is assume that this court is not with me on the four conditions, i.e. it interpolates them as a matter of statutory construction. I succeeded on showing the tribunal that three of them were satisfied, but that is cross appealed against me. And my Lord, we have set this out at some length in our written documents, and the tribunal effectively agreed with us, so I will, if I may, take this briefly. But the key point in my submission is what this hearing was as a strikeout application, and indeed what it was specifically directed to be, and that is at Supplementary Documents, Volume 3, page 653. There was a debate before the tribunal as to tab 23, page 653.
Thank you.
There was a debate before the tribunal as to whether this should proceed by way of preliminary issue or effectively strike out summary judgment. And the tribunal directed, at my learned friend's instigation, it proceed on the facts set out in the pleadings and assuming them to be true. And at paragraph 32, the facts therefore assumed to be true are that the applicant has breached Principle 8, failed to manage the conflict. 2, the failure to appropriately manage the conflict resulted in a substandard investment management service being provided to both the external fund and its investors. And then little 2, the failings by the applicant were such that the level of service received by the investors was below that which could reasonably be expected to be commensurate with the fees paid by the investors. So what is assumed to be true is that the failure to appropriately manage the conflict not just resulted in a substandard service, but that substandard service had a value below that it was worth less than objectively would be expected from the fees paid. And in my respectful submission, once you assume those facts to be true, clearly you have loss. And that is a standard principle of English law. Now, that's not to say that we don't have factual allegations as to why that is true. We clearly do. You can see those at, for example, page 587 of the supplementary bundle, going back to the statement of case, tab 17. I'll just summarise them, but the court can read them for itself if it wishes, but at paragraph 58 to paragraph 60, we draw attention to how the vast majority of the traders from the external fund are transferred to the internal fund within an extremely short time of the internal fund being set up, and all the new recruits are then sent off to the external fund. We plead at paragraph 71 to 73 about an unsatisfactory computer algorithm that is used for the external fund but not the internal fund. We plead at paragraphs 81 and 155 for failures of disclosure. So we have all of these matters for trial, but none of that really matters for these purposes, because it's an assumed fact for this strikeout that the service received was worth less than objectively was paid for it. And once you have an application that assumes that X was paid, but the objective market value was less than received, then you have satisfied the requirement to prove loss under the English common law principles, although quantifying it will be a matter for trial, exactly how much less it was, and are we using an appropriate proxy. Now, we set those out in our reply skeleton at page 216 to 217, and that's tab 13 of the core bundle. We set them out in greater length and cross-refer, if I may, to supplementary bundle 3, tab 25, page 743 to 750. So this is our skeleton below. And since we deal with more shortly in the appeal skeleton as we succeeded on the issue, may I, given the time, simply direct the tribunal, if it would be willing, to read paragraphs 62 to 70 of those submissions below, which are effectively adopted by the tribunal. And I will then just show two key passages from the authorities. So firstly, in authority file 3, sorry, authority tab 92, page 2528. So this is from Chitty contracts. My Lord sees on 25, so the heading is at the bottom of the previous page, 2527, shortcomings in contracts of service. And just picking up by the first hole punch, as my Lord sees, there's a sentence that begins, however, Sir Thomas Bingham MR, 2528. It's 10 lines from the end of the paragraph. However, Sir Thomas Bingham, Master of the Rolls, said that if there is a clear difference between the market value of what was contracted for and what was supplied, the difference will be the measure of damages. And this has been confirmed by dicta in the Supreme Court. And in this case, it is an assumed fact for the purpose of this application that there was a difference in the market value of what was received and what was paid. That's the whole point of the assumed fact on which this application proceeded. And to give an example of how this has worked, one can see tab 28, page 484 of the authorities bundle. This is the white arrow case. So 484 down the bottom of 484, it is on the other hand obvious that in the ordinary way, a party who contracts and pays for superior service or superior goods and receives a substantially inferior service or inferior goods has suffered loss. And then there are some examples. If A hires and pays in advance for a 4-door saloon at £200 per day and receives delivery of a 2-door saloon available for £100 per day, he has suffered loss. My lords and my lady could read the other examples about restaurant meals and violin teachers. But in each case, the point is the same. You pay X, but the market value is less than X. So one sees the principle summarised on 486. In my opinion, at the bottom, in my opinion, the judge was right on the facts of this case in his analysis and his conclusion. It is not the law that an innocent party who contracts for a deluxe service and receives a substandard service is in principle denied a claim to more than nominal damages. If such were the law, it would be defective. But it is the law that an innocent party in such a position must quantify, or at least provide evidence from which the court can draw an inference as to the difference between the value, usually the market value of what was contracted for, and the value, again, usually the market value of what was provided. So in this case, for the purpose of the strikeout, it's assumed there is a difference between those two factors. And of course, I accept at trial I will need to provide evidence to either quantify it or allow a sensible rationale to be put forward. But for the purpose of the jurisdictional strikeout application, loss is clearly pleaded in those assumed facts, which I showed you and taken from 173 of the pleading of the amended statement of case, and indeed the unamended statement of case. My Lord will see the sort of most famous example now of the Force India case, which is at tab 25, page 748 of the authorities bundle.
Which tab?
I apologise, it's tab 37, page 866.
Which page within it?
I apologise. So if one picks it up at page 866, the facts of this case are that somebody paid for the ability to test drive a Formula One motor racing car for a specified number of hours on a racing track. He was not given that number of hours and brought a claim. One basis of proving his loss was said to be he would have made lots of money as a Formula One motor racing driver, but it was held that was so speculative a career and so competitive that damages, I think, were about £100,000. But he succeeded in a much more substantial award of damages for the reasons set out if one picks it up at paragraph 435, 6 lines from the end, where the skimped performance consists of the supply of inferior and cheaper goods than those ordered and paid for. The shopkeeper has to refund the difference in price as damages for breach of contract, and that's very, very historically well established in sale of goods cases. Where the defendant provides inferior and cheaper services than those contracted for, the approach prescribed by Lord Nichols presumably involves refunding the difference in price between the inferior and cheaper services supplied and those which the defendant agreed to supply. And it's on that basis that he proceeds to award the damages that he does. My Lord sees the final conclusion at paragraphs 486 and 487.
That's a reference to Lord Nichols in what case?
Attorney General Blake, I believe, my Lord. And these principles are then affirmed by the Supreme Court in one step, which is an authority at tab 53, and the sideline is at page 1374. Yes, it was Attorney General Blake that Lord Nichols set it out. So we set this line of authority out in great detail in the passages of our skeleton for the tribunal to which I referred to you. But in my respectful submission, it is clear beyond any possible doubt that on these assumed facts, we have clearly established loss and causation. And the only other condition, you'll recall, was this correspondence between him to whom the duty was owed and him who suffered the loss, which is very difficult to articulate in a sense in a crine case as to who the duty was owed, but we say it is clear that to the extent necessary and for the reasons set out by the tribunal, there was such correspondence. And if I can just show you what we say at paragraph 80, so tab 25 of the supplementary bundle, page 757. sense, the third condition ignores the fact that when the courts are faced with a situation where either privity of contract or pre-existing characterizations of duties of care might prima facie preclude a remedy, the authorities will strive to ensure that the loss and the remedy do not disappear into a black hole. So just reading out from Offer Hall from paragraph 80.1 of my skeleton, the authorities in this area demonstrate the court striving to ensure that wrongdoers do not escape from their liabilities by reference to the general principle that a person can only recover from his own loss because of the happenstance that a cause of action lies in the hands of someone other than the person who suffered the loss. The courts are concerned to see that justice is done between the parties. And I think the way the case is put against me is that if the external fund is the only client, it has the duty owed to it, but the losses are ultimately suffered by the investors, because in a sense, the fund is neutral, it just sort of receives money and pays money out. I mean, I'll let my learned friend develop as to why he says I haven't satisfied the third condition, but it's that sort of idea that ultimately it's the investors who are out of pocket. I mean, we say it doesn't work as a matter
It's
of
the investors who you've ordered the redresses to be made to.
Yes, precisely. But I think my
So
learned
it's a
friend...
simple point that the duty isn't owed to those investors, as I understand it.
Yes, and we say, I mean, it's partly a reason why the correspondence condition is simply unworkable as a matter of statutory construction, but also on these facts, yes, we order the redress to be paid to the underlying investors. They obviously are the ones who are substantively out of pocket at the end of the day, but that is just a matter of logistical convenience. We could equally as well have ordered it to be paid to the external fund, which had the contractual duty and which suffered the loss insofar as these fees were overpaid, in order that the external fund then reimburse it to the underlying investors. The case cannot depend upon the mechanics of the redress scheme in our respectful submission. So, my Lord, those are our submissions, subject only to answering 4 questions which my Lord raised yesterday. Firstly, does the term redress appear in FSMA other than in sections 404 to 40G of FSMA? Once, section 3287C. I don't submit it has any relevance to the issues that we have addressed or raised, but it's there for my Lords to see. 2, does the appeal in Avocade case, in which my Lord Justice Popplewell correctly recalled he gave the sole judgment when it went on appeal, relevant to the issue to which I adverted to the first instance decision, namely quantum and the assessment of loss? The answer is no, and that's because the appeal was on liability and the quantum matters would only have arisen if the liability appeal was successful, and it wasn't. Question 3, do the rules made under section 404 require consultation in advance? You may recall I showed my Lord 404.9, which required consultation with the Financial Ombudsman Service. The rule is also, because it's a rule-making power, it's also subject to the general consultation requirement in section 138I of the Financial Services and Markets Act. Before making any rules, the FCA must both consult the PRA and publish a draft of the proposed rules in a way appearing to the FCA to be best calculated to bring them to the attention of the public, must be accompanied by a cost-benefit analysis, an explanation of the purpose, and a number of other matters. But I think, my Lord, that's what my Lord had in mind in adverting to the rule-making, the consultation requirements of this rule-making power, and it's at 138I. And finally, my Lady Justice Falk asked in the pleading for the second contested amendments, we refer to italicized passages from the Regulated Activities Order. The regulated activities are making arrangements with a view to transactions and arranging bringing about deals and investments. They are quotes from Article 25 of the RAO.
I think that was me, but never mind.
I do apologise, my Lord. Now, my Lord, unless I can assist this court further at this time, that is my share, as it were, of the first go.
Thank you. Thank you. Mr. Herbert.
My lords, my lady, can I start by just signpost what order I'm going to take things in? I'm going to adopt the same broad order as my learned friend in addressing the two main issues. That's actually the opposite of the order which we argued them below, hence the reason that the tribunal has dealt with the issues in the opposite order, but it makes a certain amount of sense. So I'll start with the power to impose the single firm redress requirement. Within that, I propose first to address some general remarks on the ambit of the power, on the authority's construction, the ambit of the power to impose a redress scheme under 55L, if that were the true construction. Secondly, I will go to the detailed questions of construction as to how one looks at the source of the redress power. Third, I'll address the derivation of the four conditions. Fourth, we will address the assistance to the interpretation which the court may derive from the Human Rights Act or from the common law. And in keeping with Mr. George's practice, we will also, having regard to the practice direction, Mr. Burgess on my side will address the court on that matter. And then I'll finally, on the first half, come on to the case, the reasons why we say the authority's pleaded case does not meet the four conditions. Lord, my lady, with the court's permission, I do want to start by focusing for a little while on the ambit of the authority's power to make a single firm requirement on their case. Because before one dives into the detail of construction, we do submit, as the tribunal also did, that it's important to appreciate what is being contended for in broader terms. Learned Friend's case certainly has the merit of simplicity. What he says is that the power is squarely based on the very broad power to vary permission in section 55L, and that 404 F7 does not impose any constraints whatsoever on the exercise of that power. At most, it's not quite otiose because it provides some auxiliary help, he says, at the margins, and effectively 404B, the ombudsman power, is what is relied on there. There was some flirtation with 404A 1M debts, but Learned Friend didn't perhaps push that strongly, and we say that that doesn't work. So accordingly, Learned Friend contends the authority can require a firm to pay consumer redress as long as the authority contends that to do so is desirable to advance one or more of its operational objectives. And here, of course, we're talking about the consumer protection objective is the one relied upon. And that power is, on challenge, subject only to a judicial review stroke rationality style of control by the tribunal, because when challenged, this goes to the tribunal as a non-disciplinary reference. I will, of course, come on to, I fully accept it's JR plus, what's sometimes referred to in the administrative court as heightened scrutiny, which even in the administrative court is appropriate in some circumstances, such as contended human rights violation.
I've never, I'm afraid, really understood what's meant by anxious scrutiny.
No, well,
one would hope that the scrutiny would be sufficiently anxious in every case.
Yes, yes. I said heightened scrutiny rather than anxious because it's a particularly problematic term, but even heightened scrutiny has a quite elaborate jurisprudence in the administrative court as to one, when it's applied, and two, what. But
you're right, it's a public law concept.
But I'm not going to go into the public law concepts. One can look at the actual statute here and one can see what it is, how this goes a little bit beyond judicial review, particularly goes beyond it on facts. But I'll come back to that. But the fundamental proposition at this stage, looking at the wider picture, is that the judicial control of this very broad power, with a very broad trigger, is by way of a judicial review style of review. And specifically, of course, the authority denies that it has to be satisfied as a precondition for the exercise of the power, that it has, that the firm, which is being ordered to pay redress, has actually caused any loss to any person by virtue of any wrong, or in fact that there even is any loss let alone any loss commensurate with the redress being required.
And by loss, you here mean financial loss?
Financial loss. Or it's not even, well, obviously it's not required to prove any loss at all, or even any other loss. I mean, Mr. George's case is that...
Or detriment?
Or detriment.
Well, that wasn't, I think, what the tribunal were dealing with. They were dealing with financial loss.
Well, that was because in this case, on the facts of this case, it's as it were proving a negative. I mean, the authority's case that doesn't have to prove anything by way of any sort of loss, whether financial loss, whether detriment, whether anything else. Effectively, all its conditions are there are no conditions attaching to loss, which are a precondition to the exercise of the power. That must be the authority's case. All it has to be satisfied of is that it is desirable, advancing the objective, to impose the variation. So at the moment, I think the canvas is the absolute widest on the authorities, not the authorities' position. We submit that, milady, that as well as not being justified as a result of statutory construction, and we do say the statutory construction arguments are in our favour on their own 2 feet, but that it is relevant to take into account, as the tribunal did take into account, that power being claimed would be one of extraordinary and improbable amplitude. And I'd like to spend a few minutes just enumerating a number of reasons why that's the case at the outset. The submission which confronted the tribunal and which confronts this court is, in the first place, entirely novel, because this power, the own initiative variation of permission, or OIVOP, to give it the rather horrible acronym, has never been exercised before this case. Despite on the authorities' case, it having existed ever since the original act in 2000.
I mean, it's never been exercised at all. It's never been exercised to impose a single firm redress scheme.
Never been exercised to oppose a single firm redress. There have been many variations of permission, I should say. Never been exercised to impose a single firm redress scheme. My Lord, that's an accurate condition on what I said. And I should say at once that the list of 6 purported previous exercises of the power I'm not going to turn it up, it's paragraph 22 and subsection A of the authority's reply, C13, only in 2 instances of those, that list was the power exercised before this case, the BlueCrest case, and both of those cases were voluntary applications by the subjects for the imposition of the requirement, which leads to an imposition under section 55L5, not as here the non-voluntary imposition of a requirement under section 55L3. So this is the first example of the exercise of the power being imposed on a firm.
The voluntary applications, do I understand correctly, come about because the FCA puts forward something which it regards as something which it's entitled to impose, and then there's a negotiation or a flat acceptance of it, from which one might imply that at least in those 2 cases, that was the power that the FCA was initially seeking to exercise.
Lord, yes, there could be a number of factual situations, and the one your lordship puts to me seems the most likely. The FCA wants redress to be agreed by the firm, and the firm is prepared to do so, and there's a negotiation, and it's embodied, and it clearly indicates that the authority thought it could exercise the power. Yeah. My point is that this is the first occasion on which it's effectively been contested, and where there's been a forensic examination of the basis of the power.
Right, I thought your point was that it was novel in the sense they'd never purported to have the power exercised in this way, and that didn't seem to me to be entirely consistent with your acceptance that there were 2 cases.
No, well, it's the first exercise under the specific subpart of L, but I accept that there are 2 previous examples of it happening voluntarily.
Thank you.
Lord, lady, we also say that the power in the form claimed by the authority is not subject of any relevant guidance or other form of detailed treatment which elucidates its application by the regulator. On the contrary, as I'll come on to, there is other legislation, and the authority's own consistent guidance, which we say strongly indicates that it considered that Section 55L is not a self-standing power, and that our contrary interpretation of the power is the correct one, under which Section 404 F7 effectively creates, breathes life into, and crucially confines the use of the Section 55L power by requiring the 4 conditions. Lord Lady, we say any power to impose redress based merely on the satisfaction of the authority's test of advancing a consumer protection objective would be extremely broad and therefore very difficult to constrain in substantive terms because of the subjective and at-large nature of that statutory objective, especially when wielded by a specialist regulator. And that position is not materially assisted by the ability to make representations or by the ability to refer the matter to the tribunal on the basis of the jurisdiction already referred to. Because it's self-evidently difficult to see anything on which a judicial control can bite where there are no specific conditions attaching to its exercise. Indeed, the power is so broad that even if it were being exercised by the tribunal itself as an own power, standing in the shoes as it were, as its own decision, that would not remove the vice to which I'm referring, because the tribunal itself would be possessed of an extraordinarily broad and unconstrained power. My Lord, we do say that it's counterintuitive at a very basic level for what is asserted to be, acknowledged to be a consumer redress power that Parliament would have intended such a power to be exercised shorn of such basic requirements as to what, as we say, constitutes what redress is. The authority at first instance went so far as to label the 4 conditions as prescriptive and technical conditions. We say they're not. We say that they are, at least in combination, fundamental to any rational or fair redress requirement. And it's not enough to say, well, they may well be required as part of a rational decision. One can leave all that to the evaluation of the tribunal or representations being made. The point is that the authority has clearly disclaimed that the 4 conditions are necessary for a rational decision. They have not, and they don't accept that they are required to be satisfied of any of the 4 conditions in order to reach a rational decision. If they did accept that, we could abandon most of the argument and go on to look at simply whether they had properly pleaded their case, because otherwise the decision would be irrational. But that's not the situation, the case I face. We also say that the asserted power is aberrant in that it is out of line, radically inconsistent indeed, with the toolkit, the regulatory toolkit of other powers which Parliament has chosen over time to confer on the regulator to secure redress for consumers. The most obvious analogous power, and the one in which we will place the greatest reliance, is of course the multi-firm redress power, which has existed since 2000, although it was significantly reformed in 2010. And that power essentially allows the regulator to do the same thing for a group of firms systemically, which may systemically need, in the regulator's view, to pay redress to consumers. The same thing as the single company allows for one firm, as in this case. And the single power is, of course, expressly linked in the legislation, corresponds to or similar to the multi-firm power. It's common ground that the multi-firm power requires the 4 conditions. And we do say, before one even gets to the statutory construction, that it is in the highest degree improbable that Parliament did not contemplate that the same conditions would be applicable to the exercise of the single company power. There's also a broader toolkit of other regulatory powers which we say support the argument, but obviously the multi-firm power is the most important and most pressing comparator. And so we do invite the court to regard with deep suspicion the authority's case that, in a sense, with one bounce is free, the basic requirements to be satisfied that consumers have actually lost anything or that the firms responsible for it, when these sorts of conditions are responsible across a broad range of powers elsewhere. Indeed, on our side of the courtroom, we have scratched our heads and tried to look at whether we can find any comparable example of a power from any field of professional or economic regulation, where a regulatory body is able to impose unlimited redress on so broad a basis that it considers to do so would advance a very general and high level of objectives such as market integrity, consumer protection, subject only to a judicial review standard of review. We have drawn a complete blank. We can't find any power in any other form of regulatory life, and certainly none has been suggested. I've made that point before. None has been suggested on the other side of this court. We say that when the work of statutory construction is done, having regard to the fact that the legislation has been through a number of iterations since 2000, and we do say that the chronology, the history of this is really important. My own friend rather downplayed it, but that the historical evolution is hugely important. We say that what emerges is a clear and deliberate scheme by Parliament in 2010 to align the new single firm redress power, having been no such power before, with the pre-existing multi-firm redress power, which was simultaneously being relatively radically amended, being given to the FCA, effectively, with the authority for the first time to exercise. It created analogous triggers for the exercise of the power, and as I'll come on to, those triggers are found in section 404A, which, as might be expected, require the same four conditions to be established in the case of a single firm scheme as are clearly and admittedly required in the case of a 404 multi-firm scheme. And that scheme therefore created is rational and subject to the expected checks and balances, and avoids a situation which we would also contend violates fundamental common law principles and would violate Article 1, Protocol 1 of the European Convention if the power was as unconstrained as is said. I'll come on to that in due course. Can I, against that background, to turn then to the more detailed work of statutory construction?
Can I just explore that a little? Suppose that you had a firm who had in the past indulged in misogynistic and bullying behaviour, and the FCA wanted to impose a condition in relation to continued permission as an alternative to a prohibition, where you had circumstances where the firm said, "We're terribly sorry, but we're going to put all that right, and we're very remorseful about that, and it won't happen again." And the FCA said, "Well, that's all very well, but actually, you need to put your money where your mouth is, and what we would like you to do is to have an investigation as to which employees may have been subject to this behaviour, and to pay them £100 a head as a result of your past conduct." Now, that would be an example of a case in which there need not have been any actionable breach of duty, loss, or causation. But would it be surprising if the FCA were able to impose that as a condition to continued permission as a fit and proper person?
Well, in the first place, I do say it would be surprising, because this wouldn't be the exercise of a redress power. in any sense at all. It would be, I mean, the FCA would have a number of different routes in that case. I mean, non-disciplinary financial misconduct is, of course, a hot topic and is something which the authority can investigate, and has made plain that it will do so. And of course, there may be consequences for that, from following from that. But it is something I can consider furthermore. But my first reaction is it is not something which would be an appropriate use of a variation of permission to, as it were, require compensation payments to be made under what would presumably be under the ordinary law, rather than under a FSMA power.
Well, it would be a 55L own initiative condition of
Yes.
continued permission. That would be
It
that would be
indeed.
the power that would be purporting to be
Yes,
exercised.
indeed.
I'm hypothesising.
Yes.
And it would be imposing a form of redress which involved both investigation and payment of money. In fact, in the
Yes.
present case, we don't have the investigation element, but just to that extent, it's akin to.
Yes, my Lord, yes, and
a
certainly
redress
I would accept that the power of investigation. I mean, a number of routes in which investigation could be launched, but it certainly I would accept that potentially it could be subject to if there was a route through to effectively establishing liability, then I accept it could be the subject of a redress scheme. But I do say it would be surprising, absent any of those matters being established, to say that we think it's a good thing to pay some money to employees. It might be extremely deserving, but it would be a use of an unconstrained power to compensate for alleged conduct which the firm was responsible.
Sorry, can I just, before we do that, but that would be something that the Ombudsman would have power to do, isn't it? If there were a complaint by an employee.
Well, no, Lord, I think probably not, because I don't think it would come within the Ombudsman's jurisdiction. It wouldn't be a complaint in relation to a financial service. There are quite tight rules as to what the Ombudsman can look at. I think it's highly unlikely that the Ombudsman would have any remit whatsoever in that situation.
Can I understand, is your case essentially that at least before 2010, because I think you are saying that multi-firm schemes could exist before 2010, single firm schemes couldn't, but are you actually saying that there was no power before at all for 2010 for a requirement under section 55L to involve a need to pay money? Is that what your case comes down to?
Milady,
You can do investigations.
Milady, it does come down to that. It does absolutely. It's 45. Of course,
in
it's
any
45L
form.
at that stage, and I will come on. One thing you haven't been shown, interestingly, although my friend is the person who asserts that the power has existed ever since 2000. You haven't actually looked at that original power as it existed between 2000 and 2010. That's one of the things I'll come on to, and I would say that there was no power to require a payment for past misconduct or any past conduct at all.
Right, no, but are you actually saying no power to require payment full stop?
Yes, Milady, I think that's right. I'm hesitating only to think about whether there could be any requirements to make payments which were not part of a redress. We say there's no redress power in the 2000 Act at all.
You've used the term redress.
Yes.
The term redress doesn't appear in section 55, which is why I'm sort of trying
Yes.
to 55L. So I'm trying to understand what the sort of fundamental point.
Yes, Lady, I think I'm saying that. My case does extend as far as to say that there was simply no power to require payment. Yes, of course, there are other powers under the Act. Restitution power is being mentioned to me. There are, of course, other powers under FSMA, but answering your ladyship's direct question about the Section 45 power.
And just then to build onto that, you've mentioned the restitution power. You've effectively said no single firm redress scheme before 2010, and then only within 404 F7. So if there had been a desire to require payment of money in a single firm case before 2010, are you saying the only route would have been the rest? Leaving this to one side, the Ombudsman for a moment, are you saying the only route is restitution?
Lady, that must be right. Either the court ordered restitution 282 or own initiative power in Section 384. Those would both be routes which were available at that stage.
And if there was a power to order restitution, it's your case, I think, that nevertheless there wouldn't be a power to make such restitution a condition of continued permission.
Indeed, my lord, I do say that.
Thank you.
So may I take the multi-firm power first, as it was in 2000, and then come to the single firm power thereafter. As enacted in the original Act, if I can take you shortly to see that, because I don't think you were showing those provisions, and just it is helpful background. It is in the first volume of the authorities, for those who haven't taken it out, at page 30. It's tab 2. So this is tab 2. So it may Lord be taken out. It's the tab 2 provisions, which are the original Act provisions.
Yeah.
And within that, it's page 30. And what one sees there is a power conferred on the Treasury, not on the authority, to impose what we describe as a multiple firm redress scheme. The scheme could be imposed, and this is subsection 1, only where the Treasury was satisfied that there had been that there was evidence suggesting that there had been a widespread or regular failure on the part of authorised persons to comply with rules relating to a particular kind of activity, and B, that as a result private persons have suffered or will suffer loss in respect of which authorised persons are or will be liable to make payments, compensation payments. And the authority was required, you can see from subsection 4, to produce a report setting out the details of the alleged failure and of the scheme proposed, and the Treasury would then obtain parliamentary approval for the scheme, and if obtained, would authorise the authority to establish and operate the scheme. You see that in 404.2. So it was the authority was the ultimate recipient of the power to administer the scheme, but it wasn't, as it were, at least in formal terms, the initiator of the power or the exercise. Now, as you have already seen, in 2010, this power was substantially amended in the FSA 2010, amending section 404 and then adding a number of new provisions, 404A to G.
Before you get to that, you said, did you say that the Treasury would obtain parliamentary approval?
Lord, yes.
And where do we find that?
I apologise. My note says it's in 404, but that's a misnote because it must be in
There must be a general.
There must be. I apologise. I had thought it was in the part section, so but it isn't. So can I supply the details, Lord, when we've tracked that down. And the 2010 amendments, of course, for the first time gave the authority a rulemaking power to establish a multi-firm consumer redress scheme, but subject to significant limitations and restrictions. I'm not going to go back through the detail of section 404, which Milan Trent has already carefully taken you through. But I would the outcome of his analysis was that he accepted that it was as common ground the authority was permitted to impose a multi-firm redress scheme only if all four conditions of loss of four conditions which we rely on were satisfied, and section 404(1)(b) makes that position crystal clear. And then one has section 404A, rules under section 404, supplementary as they're called, which then, among other things, we say effects the limitation on the scope of a multi-firm scheme which have already been set out in 404(1)(b). In other words, for present purposes, the needs for the four conditions.
I'm sorry, this has been troubling me. The four conditions: loss, causation, duty, and actionability. I can see in 404(1)(b) causation as a result, loss, consumers have suffered loss, and actionability, if they brought legal proceedings, a remedy would be available. What generates the duty, and what is the duty? Because in some places in the tribunal's decision, the duty seems to be a failure to comply with a requirement. But I think you say the duty is more than that. It has to be a duty owed to the consumer.
In a sense, in preparing for this case, I wondered if I should have said 5 conditions, because there is plainly a duty as a requirement. I mean, that it's not. We said it's clear there has to be a requirement breached, but your lordship is absolutely right, and I accept it's the refinement that my learned friend also put when he talked about it. It is in a way a correlation of breach of the requirement with the person to whom the redress is effectively being ordered for. So
where do you get that from 404(1)(b)? Because you said all four conditions were found there.
Yes. Well, because consumers can only be redressed if they have suffered loss which, if they brought legal proceedings, a remedy or relief would be available in the proceedings. Now, if consumers brought legal proceedings identifying a failure to comply with the requirement, they would, in our submission, have to establish that that requirement gave them a cause of action before they were able to claim.
Why is that different from the actionability condition?
Well, we do say that they're, as it were, two separate points. Although in many cases they will go together. It has to be a requirement which has the nature of actionability, so that the principles are obviously a good example of something which are not actionable. But it also has to be actionable at the suit of the person to whom the redress is offered. And so, for example, if there's a proposal to redress the external fund, the investors, when the duty is owed to the external fund, even if whether they're actionable or not, that is a separate objection. So there might be one objection that what you're relying on is Principle 8, which is non-actionable. There might be another objection that you are proposing to redress investors, but actually, on your case, the duty was owed to the external fund. So there's a mismatch there, and that is what I've identified as duty. Duty is obviously too short a word to comprehend it, but we do say that they are two separate, although obviously closely interlinked issues.
So you say it's a necessary element of actionability, which is what 404(1)(b) supposes, but actionability is itself an additional requirement because you could have fulfilment of duty in that sense in cases which weren't actionable in law.
Is it any more than saying it has to be actionable by the consumers who've suffered loss?
Lord, that puts the two together. That's a convenient way of expressing together actionability and duty in my submission.
Yes, I'm just wondering. Yeah, I mean, you may very well be right that it's implicit that if consumers can obtain a remedy in legal proceedings for loss that they have suffered, that means the duty must be known to them.
Indeed.
But I don't think it logically necessarily follows, because you could envisage a situation in which A owes a duty to B, but nevertheless C can sue for loss, and that may not be. I mean, that may be an empty class, as it were, but it's definitely a separate question.
Lord, I can see how, at least in theoretical terms, it's a separate category. It's certainly not one which anyone has sought to bring forward, and certainly for present purposes, I don't think it's something which needs to derail the theoretical analysis. And when one comes on to the 404A,
The practicality of it in this case is, you say, even if we did something wrong, we didn't do anything in respect of which the investors in the external fund have a cause of action against us.
precisely on the pleaded case against us.
Yes.
Learned Friend dealt with that at the very end of his submissions and said it can't possibly, that's a mechanistic point, it can't possibly be significant. We say it's hugely significant. And one only has to imagine a situation in which the FCA that the authority requires us to redress investors, and then the external fund sues us. I mean, there are complicated issues about, in any case, settling with the party to whom you don't owe, and then someone else who we're not taking refuge in technical points here, or we say at any point in our argument. There are real issues there.
Well, I think I now understand why you say it's implicit in 404(1)(b). Thank you.
And so when one turns over, it's very helpful, Milord's questions, because that provides a helpful starting point to what happens when one looks over the page at 404A and asks how the position set out in section 404(1)(b), how it is actually affected, because section 404A, we say, is effectively it's the plumbing, it's the mechanism by which the result set out in 404(1)(b) is achieved in relation to what scheme rules may or may not make permission to do. And I take the position now addressing it in the multi-firm rules, but of course I'm anticipating much of my argument that I'll be making under the single company rules, which apply to this too. Because we say that when one looks at the combination of the rules, particularly in 1C and subsection 3 of section 404A, one does see a scheme which requires all of the four conditions. They can all come out of this. One can see just before there, one sees that. First of all, it's worth noting that 1B and subsection 2 before one gets to 1C and 3. 1B allows the authority to set out in relation to a specific description of case examples of things done or omitted to be done that are to be regarded as constituting a failure to comply with a requirement. So it's going to be very helpful for the firm to be told these are the sorts of things that you've got to put a cross on and move to the redress stage of your argument.
And can those include things that don't in fact constitute a failure to comply with the requirement, but
No,
the rules say that they are?
2, and subsection 2 says the only examples that may be set out in the rules as a result of subsection 1B are examples of things done or omitted to be done that have been or would be held by a court or tribunal to constitute a failure to comply with the requirement.
Thank you.
So that's the first. This is a very careful legislative stage to make sure that the protections that the 1B 404(1)B position is adhered to. And one then, after that, comes on to 1C, which sets out, in relation to any specific description of case, matters to be taken into account or steps to be taken into account by the relevant firms for the purpose of, first of all, assessing evidence of a failure to comply with a requirement, and then determining whether such a failure has caused or may cause loss or damage to consumers. May cause is obviously anticipating a situation where the loss may not have eventuated yet. And then subsection 3, matters may not be set out in the rules as a result of subsection 1C if they have not been or would not be taken into account by a court or tribunal for the purpose mentioned there. And for the purpose mentioned there must mean the two purposes identified in C1 and 2. The first is assessing evidence, and the second is determining whether such a failure has caused or may cause loss or damage. And we say that those supplemental provisions, again, make it crystal clear that the four conditions apply. And I'll come on to this in relation to the single firm in detail one by one, but we effectively say that the rules could not require a firm, taking the C1 first, couldn't require a firm to assess evidence of a failure to comply with a requirement unless the court would consider evidence of failure to comply with such a requirement for that purpose. So rules couldn't require a firm to assess evidence of a failure to comply with Principle 8, for example, as non-actionable, because a court would not assess evidence of failure to comply with a non-actionable requirement for the purposes of the section, for the purpose of imposing redress. A court would not determine whether a failure to comply with a non-actionable requirement caused loss and damage. Or if one's asked about the duty requirement, which my Lord Justice Nugee asked me specifically about a moment ago, the court would not assess evidence as to a failure to comply with a requirement, which requirement was not a duty owed to the persons claiming. And so we respectfully don't see any difficulty in deriving all four of the conditions out of section 404A, and that is hardly unexpected, given we say that was what the legislator was aiming to do. Thinking about this as a multi-firm scheme. And one other feature of the multi-firm scheme that I should perhaps draw the court's attention to, and that's 404D, which is on page 183, the same tab. And this provides routes of challenge to a multi-firm scheme. And one can see that it provides for an application to a tribunal for a review, and I ask the court to note the word review of any rules made under section 404. And then you'll see this is really a judicial review procedure. In subsection 3, an application be made only if permission's been first obtained from the tribunal. The tribunal may grant permission if it considers that the applicant has a sufficient interest, so you've got to show standing and you've got to get permission. And then subsection 5, the general rule is that in determining an application, the tribunal is to apply the principles applicable on an application for judicial review. What one sees quite in general terms, quite an abstentionist jurisdiction in relation to a multi-firm scheme, subject to a very important and for our purposes relevant restriction, which is subsection 7. It says if, or so far as, an application relates to a matter set out in the rules as a result of section 404A1C, the very section we've been looking at, the tribunal may determine whether the matter should be taken into account as mentioned in that provision. So that is making the tribunal the primary decision maker. It's saying this is not a judicial review jurisdiction for this particular purpose. This is making the tribunal the person to determine whether the matter should be taken into account or not. What it is doing, very importantly, is protecting the four conditions effectively from being simply a matter which the regulator decides, subject only to a judicial review jurisdiction. It is giving a heightened control by the tribunal over that question, which Parliament is singling out as a really important constraint on the making and exercise of a multi-firm scheme. And again, we would say it'd be very surprising if, by comparison, a single firm scheme simply left all this to the authority's conception of desirability of advancing its objectives.
But do you say section 404D applies to a single firm scheme?
No, no, we don't. Instead, one's looking at the different regime.
Even though it does apply to a multi-firm scheme. So that's one aspect of a single firm scheme that isn't carried over. Sorry, one aspect of a multi-firm scheme that isn't carried
understand
over.
why it's done differently, because if you've got a multi-firm scheme, you might have 10 people wanting to challenge it. It's a different. For a single firm scheme, you can have a reference to the regulator in the normal way and have a decision between. Here, it's recognising that this is a challenge to rules made, which may affect many people. You have constraints on who can come in and challenge, and then you set out the jurisdiction. So
It's a challenge.
It's a clear difference.
It's a challenge to the exercise of a rule-making power. So it's not very surprising, really, that it should be that challenges to it should be on public law grounds, essentially, because it's an exercise of statutory power.
Well, if I may say so, that would be a slightly formalistic justification of the difference. I mean, your lordship is absolutely right. It is a rule-making power as opposed to an exercise of a variation of permission power. But part of my submission is Parliament was not treating it was treating it's looking at the substance of what the authority is doing in either case, and whether it's doing it by making rules under 404A, or whether it's going to be doing it by addressing those conditions by a variation of permission. And so we say section 404(7)A, importing the same conditions. In substance, it's having to take the same decisions, the same judgments.
And yet you say this doesn't apply in the latter case.
No, but this doesn't apply. One gets the protection in the single firm scheme from the reference to the tribunal that we'll come on to, and the way that jurisdiction operates. The point I was making at this stage is that the procedure which has been designed for challenging rules in circumstances where you might have multiple claimants is this. But even here, they don't leave it at judicial review for the four conditions. They ensure that the tribunal's got heightened control over that.
If I understood it correctly, that in a multi-firm scheme, you make rules under 404A, but in a single firm scheme, which you accept now can be done, you don't make rules under 404A. You just impose requirements.
Exactly, which correspond to or
correspond to the rules.
Precisely.
And it's because you're not making the rules that all these provisions don't apply directly, but you say they inform the scope of what the corresponding requirements can be.
Precisely. They still set out what you are permitted to do. I mean, effectively, the authority is making something that looks very like rules in a variation of permission case. I mean, in our case, it's very abbreviated. It's remarkable how short the supervisory notice is. But you can easily envisage a supervisory notice which had a much more elaborate set of rules requiring a firm to do all the things that you would have in a multi-firm scheme. First of all, to investigate the matter, to see which claimants potentially fell within, to articulate the standards to be assessed, and then to have a separate section dealing with the loss calculations and principles. Indeed, in the tribunal, it was generally accepted that the very short scheme is going to need to be elaborated in those sorts of ways. Because at the moment it says nothing about, there's an internal estimate of what it may cost, but the rules are not, as it were, specified in detail as to how the redress process is going to work. So, my lords and my lady, against that background, one turns to the provisions relating to the single firm scheme, And we do say that this was introduced by the 2010 Act. It does so as part of the same Act, same part of the Act as introducing these multi-firm powers we've just been looking at. And we do say that it is helpful and important, given that the authority's case is that the Section 55L power has existed, albeit in dormant state, ever since the 2000 Act, when it was in Section 45. It is important to go back and look at that original power, which your lordships haven't seen. That's in tab 2 of the bundle, which is of the First Authorities bundle, starting at page 10. And so before I embark into those powers, it might just be helpful to show you what the tribunal said about the single company power, because it's a helpful introduction to that section. If I could ask the court, so perhaps keeping open, if you're able to, section 43, to go back to the tribunal's judgment in the core bundle at tab 15 at paragraph 237, which is on internal page 282 of the core bundle.
So sorry, which paragraph?
237 it starts at. It says there, also pursuant to FSMA as originally enacted, where the authority granted a firm permission to a firm to carry on regulated activities, it could do so on the condition that the firm complied with certain specified requirements. Thus, Section 43 FSMA provided that when granting permission, the authority may include such requirements as the authority considers appropriate. 43.1, these requirements may include the requirements to take specified action. Section 43.3 further provided that a requirement may extend to activities which are not regulated activities. And then there's footnote 1, and partly I wanted to show the court footnote 1. We say that he notes that the explanatory notes to Section 43, as originally enacted, indicate that the purpose of the power to impose requirements on permissions was to place forward-looking restrictions on a firm's permission. And then he cites from paragraphs 104 and 105 of the explanatory notes, which gives examples. Such requirements might include requirements on the authorised person to act or refrain from acting in a certain way. Subsection 5 allows the authority to specify a period during which such requirements have effect. Thus, the authority might impose a limit on the amount of a certain type of business the person may conduct during the first 5 years after receiving permission. And subsection 3, such requirements may also be imposed in respect of unregulated activities, and so on and so forth. So the tribunal derived assistance from those explanatory notes, which you have for the court's note at Authority A1, tab 5, page 197, but the judgment quotes the relevant parts of them. So that is helpful background when one comes to look at what the powers contain. Section 43 is at page 10 of the tab 2 of the bundle. And this is, of course, dealing with imposing requirements, including taking specified action under subsection 2, require the person concerned to take specified action. When you grant fresh permission, Part 4 permission may include such requirements as the authority considers appropriate.
So just pausing there before we get to section 45.
Yes, my lord.
You say that wouldn't have allowed the imposition of a requirement in relation to past conduct at all.
No, it would. This is a fresh permission. This is someone coming along and being given permission for the first time. What you don't have here, these are conditions which actually apply to that the substantive provision is actually in section 40 of the bundle, and section 40 of the Act, and if necessary we could specify that. It may have been a victim of our pruning down, but that is the section empowering fresh permission to be granted. So that's the first provision in Part 4, permission to carry on regulated activities of the Act. It effectively says, if I may just read to the court, an application for permission to carry on one or more regulated activities may be made to the authority by, and effectively allows you to grant permission. And this section 43 is keying into that. A part for permission may include, so it's keying into the fresh application for permission.
So you couldn't, so for someone who came along and was seeking permission for the first time as a fit and proper person, you couldn't impose a requirement that they must pay an outstanding county court debt?
Well, my lord, it was certainly viewed by the court as being a forward, by the tribunal as being a forward-looking power.
Well, I know, but that, wouldn't that be quite surprising?
Yes.
The example I've given you?
Not on the face of it, that might be a matter which the authority wanted the firm to comply with before it would go into authorization. But we don't regard that as being an appropriate requirement under Section 43 itself.
Well, it would seem to come within the wording of 43(2)A.
Yes. Yes.
But
Yes.
well, I think your case has to say, well, there's somewhere to be found a limitation that says you can't do that. I just wonder where you find it.
Well, my lord, I don't need it for my case because this is not a case of an application for permission. I mean, this is a.
I know, but we're going to move on. I just want to want to see see where we go as we go through the process.
Yes. Well, Lord, at the moment, I don't accept that a power to give fresh permission and to be regulating, to as it were, allow an applicant through the regulated door would necessarily allow past action. It certainly wasn't what was being contemplated in the explanatory notes as being an appropriate matter. But can I'll consider, Lord, if I may, a little further as to whether I'm right not to make that concession, if I may do. What we then say is you get in section 44 variations at one's own request, and then you come to 45 variations at the authority's own initiative, and one has the trigger power in subsection 1, which looks relatively familiar from the later power, which is includes desirability to exercise the power in order to protect the interests of consumers or potential consumers. So it rather writes in what later becomes one of the objectives. And one then has two. So one is entitled under this power to vary Part 4 permission in any of the ways mentioned in section 44(1) or to cancel it. Now, if one looks back over the page at 44(1), one looks at the ways you can vary it. A to C are all about adding or removing or varying an activity. Adding an activity, removing an activity, varying the description of the regulated activity. And then D and E are about varying or cancelling an existing requirement. Now, we say that none of those on their face could apply to a redress order, for example, a requirement for redress order for past conduct. A to C would not be relevant at all, and if there was no existing requirement, certainly there's nothing for varying or cancelling a requirement to bite on.
So if the...
But one does see...
I'm so sorry. So are you saying that section 45 didn't contain any power to impose a new requirement?
That's where I'm getting towards, my lord. There's another section to look at before one gets there, which is section 44(5), and that says the authority's power to vary a Part 4 permission under this section extends to including any provision in the permission as varied that could be included if fresh permission were being given in response to an application under section 40. And there's an analogous provision in section 45(4), effectively saying the same thing. But, my lord, as we've noted, requiring redress could and would not arise at that stage because the person would only have just been authorised. And so, on the face of that, we say it is at the very least open to question how the power could ever have been used in the period 2000 to 2010.
But leave aside for the moment redress. I think your submission is that you had a power to impose requirements under 43 when someone's applying for the first time.
Well, yes.
If you do impose that requirement, there's a power to vary it under 44. But if you haven't imposed a requirement, you can't impose a new requirement at all.
Backward-looking requirement, indeed.
Well, where do you get backward looking from? I mean, where
Yes.
Section 45 you say does enable you to impose a requirement, does it? Where do we get that from?
No, 45 allows you to cancel or vary a requirement or to add or remove a regulated activity.
Yes. So I think it is your case that Section 45 didn't allow any requirement at all, backward looking, forward looking.
Unless it's a requirement that could have been included when first permission
Yeah,
was
so
granted. That's the
Well,
crucial one in subsection 5.
45(4), you're referring there to 45 sub 4, aren't you?
And also 44.5, which is in the same terms.
Well, let's just look at 45, because that's the material.
I mean, what one you would expect this to mean is that by a combination of 45(4), which takes you back to the power to vary, and put together with 44(5),
Yes.
that a power to vary is actually a power to impose any requirement you could have imposed under Section 43.
I do accept. Well, I do accept.
Is that the right way of reading it?
I do accept that 45(4) does give you, on the face of it, gives you a power to impose new requirements, effectively. And one looks back and asks, what could you have done if fresh permission were being given in response to an application? And if it's something you could have done at the beginning when you gave first permission,
Right.
then that is something you can then do under Section 45.
And
I accept
so the
for what
reason you
is in
say,
the-
I'm so sorry, if I understood, the reason you say that Section 45 does allow you to impose a requirement, but not a backward-looking requirement, is because Section 43 wouldn't have permitted a backward-looking requirement.
Indeed, or perhaps I don't even need to go that far. It may be that there is a category of backward-looking requirements which would be appropriate, such as the one your lordship put to me. So you need to get your house in order, sort of get your house in order when you first get permission type of requirement. What is quite clearly couldn't do was to require a redress scheme or anything like that in relation to conduct as an authorised person, because one would only just be getting permission. So that is why, and I only put this as high as to say there must have been substantial uncertainty as to whether a power existed, because on the face of it, it doesn't look as if you can get to a redress power, which was something that ex hypothesis follows permission, because that's not something you could do when permission was first granted.
What about somebody who was authorised, then ceases to be authorised, and then applies for a fresh authorisation?
Then it might be possible if I can quite see if you're referring back to that previous period.
So that would be a power that that under Section 43 one might have, if contrary to your primary case, it allowed retrospective.
One might have. And the more I think about it, the more, if I may, because your lordship was a very fair question to me. I don't necessarily go so far as to say that you couldn't look back at all. I see the force of your lordship's argument. It appears to fall within the words. So require a person to take specified action. Why shouldn't specified action, well, that wasn't what was being contemplated in the explanatory notes, but why shouldn't specified action relate to something prior to permission to put your house in order, rather than saying you've got to sort that out before you come and get permission, say, well, we'll give you a few months to sort it out. So I can quite see how that could work. And it doesn't undermine my argument, which is one thing that can't come with it is anything in the nature of a redress scheme for conduct while you've been authorised. Now, my lord,
unless you fall into the category of having previously been authorised and then ceasing to be authorised.
Yes, indeed, unless you fall into that category. Look, I put this this submission aims at a slightly unusual position that I'm coming to on it. I'm not saying that there was absolutely no way that this power could have been exercised. I'm saying there must have been substantial doubt, if anyone had thought about it, which no one ever did, because no one conceived of this power being a redress power. I'm saying that there must have been substantial doubt as to whether this power was capable of being exercised, and there still is doubt looking at it on its own. And if I venture to suggest that if the authority had tried to use the power, it would have been challenged, and we would say successfully challenged, on the basis that this is not what the power was meant to be dealing with. The reason that I am limiting my submission in that way is because there is an interregnum between 2010 and 2012, when this power continued to exist and operated with Section 404 F7. It's not till 2012 that this power we're looking at now, Section 45, turns into Section 55L, which dispels the problem entirely, because there is in Section 55L2 and 3 a power under subsection 3 to impose a new requirement on an authorised firm. So the problem disappears at that point.
I understand that. The reason I'm exploring this is because I understand your arguments by reference to 404 F7, but they only come in 2012, and therefore, if there was a limitation on the ability to do this, it's either to be found in where the power was in the first place, or somewhere other than 404 F7.
But my argument as to F7 coming in 2010, because 404 F7 came in 2010.
Sorry, to 2010, not 2012. I'm sorry.
So there is this slightly uncomfortable 2-year period where there is a
But
slightly questionable variation power. But what we
I'm focusing on the 10-year period.
Yes. The truth of the matter is that no one contemplated this power existed for the first 10 years of existence. And what we say 404 F7 did, which I should now come on to, is effectively, I said at the beginning, to breathe life into, and to confine the variation power. So it may be it was nascent at all times since 2000. We say it was not. We say that you would need a clear statutory authority to exercise such a wide-ranging power, and that before you had Section 404 F7, there was simply no clear statutory authority that enabled you to exercise the power. And when one looks at it and analyses it as one does, there are substantial objections or difficulties with seeing how it could have validly been exercised, except perhaps in some of the more extreme examples your lordship gives of someone being authorised and stopping and starting again.
But it does follow from your submissions that for a 10-year period, there was an ability to set up a multi-firm redress scheme, but no equivalent ability for a single firm. Absolutely, that is, and but an ability with Parliament, Treasury pushing and Parliament pulling, and there was no equivalent to single scheme power, and that is. That vexed white paper says we're introducing a new single company power, but it may be that I can't press the white paper that far given the clouds of dust that have been kicked up. But we say that's precisely the position. In 2010, the Parliament radically amended the multi-scheme, which had been effectively not been used. It was too cumbersome. There's explanations again in Parliament as to why that was, and at the same time brought in alongside the analogous single company power.
But there was a power during that period to order restitution.
Indeed, ever since the 2000 Act, and a power in the FOS.
So it would have been
actionable claims, or lots of other. There's a whole regulatory toolkit of other powers.
It would have been necessary during that period to analyse very closely whether what you wanted to do would be properly described as a single firm scheme akin to a multi-firm scheme or restitution, before you had any legislation which referred to something which is similar to or corresponds to. That's your case, I think.
Yeah, we would say that if one analysed the single company scheme, one would conclude there was no power. Without the benefit of 404 F7, if I've understood your lordship's point rightly, that there was between 2000 and 2010 no sufficiently clear power.
No, quite. But if in this case what had happened prior to 2010 was a supervisory notice in these terms, which instead of referring to redress, say by way of restitution, you say they couldn't do that because you couldn't impose a backward-looking requirement as a Section 45 condition, rather than because it resembles a multi-firm scheme.
Well, it
you say
wouldn't
the
resemble a
latter?
multi-firm scheme, because the multi-firm scheme would have had to go, it was very different in terms. It would have been a very odd thing to do. It would have been layering power on power, because of course you can just exercise the restitution power directly. You either go to court or you actually promulgate a notice setting out the restitution requirement.
No, but there's a different function. One may be by way of sanction. Another may be in order for us to regard you as a continuing fit and proper person. You've got to do this. That's future looking.
Well, but I quite see that if a restitution scheme was imposed and obligations were placed on the firm, and the firm simply started ignoring them, or obviously if it couldn't pay, there might be capital adequacy issues, but assuming it was as it were defying and refusing to comply, those might give grounds on which the authority would want to cancel permission, most likely, or at the very least vary permission. But those would be ongoing, future-looking matters. This firm is in. It wouldn't be anything relating to the requiring redress. It would be saying that this firm is effectively defying the regulatory rules, or in some ways it would be future-looking conduct. It would be an entirely different kettle of fish, and an entirely appropriate matter for considering. It would be less likely to be a variation. It would be more likely to be a cancellation, I apprehend.
Thank you.
Well, while we're looking at it, could what the authority has sought to do here have been done under Section 384 in the exercise of the power to require restitution?
In principle, Lord, I would want to. In principle, yes, I would want to go through all the statutory requirements. I mean, in principle, the reason I'm hesitating, there's a combination of the penalty here, as it were, the disciplinary notice and the first supplementary is attached to redress.
We're looking at the single firm scheme.
Yes.
And you have said to us that as brought into force originally in 2000, FSMA did not contain in 43, 44 or 45
Yes.
any power to impose a requirement consisting of a single firm redress scheme at all. And my question is, but could the authority have achieved the same result by exercising its Section 384 powers?
Yes, my Lord, the answer I think is yes. My advocate's hesitation was only as to whether all the conditions would automatically fit. But yes, my Lord, in principle, the authority, the regulator could, and indeed even in this case, could have chosen to exercise the power on the basis that it was satisfied that an authorised person has contravened a relevant requirement or been knowingly concerned in the contravention of such a requirement, and profits have accrued, or one or more persons have suffered loss. Well, subject to loss.
Or been adversely affected.
Or been adversely affected.
And that doesn't require any actionability or...
We've accepted it doesn't require actionability, absolutely, from the beginning.
Or loss.
It requires other... Well, loss or otherwise adversely affected. I would be submitting that adversely affected is extremely proximate to loss, and it doesn't extend the jurisdiction much at all. But we've always understood.
But disgorgement of profit as well.
Yes, and disgorgement of profit. Absolutely.
That doesn't involve loss, does it?
No.
So it's not a loss requirement.
No, absolutely.
There isn't an actionability
no
requirement.
Actionability. In many ways, it's a much more flexible power.
And the authority could have done, in this case, what it sought to do in substance in its supervisory notice, but by exercising its Section 384 powers, but it couldn't do it by way of attaching it as a condition to continued permission.
No, it couldn't do it. It couldn't do it in that way, and it wouldn't need to. It could have exercised the Section 284 power against the firm, and the court and the authority has exercised 384 power and indeed section 382 power to go to court. I've appeared for the authority on a court application under section 382 to require restitution. And for example, the big Tesco compensation of investors after the misstatement of profits was a section 384 case. So it's a familiar power that the FCA chooses to exercise, but it does have some basic requirements that the authority says it doesn't have to satisfy here. The others of the four conditions, and what the authority has chosen to do here is not to use the restitution power, which it's used a number of times in recent years, and in policy statements saying they want to increase their function in this area, to increase orders of restitution to assist consumers. And what they've chosen in this case to do is something entirely new that's never been done before on a compelled basis. An exercise of power that we just say doesn't exist.
Thank you.
Thank you.
Can I then come to section 404 F7 itself? And that, of course, is back on page 193 of tab 4, the first authorities bundle. Lords and Lady, we say that the technique being used here is to provide that the existing power to vary permission or authorization, which, as we've seen, was at the very best a very dubious power in relation to past conduct requiring these to be redressed, can be exercised to impose requirements corresponding to or similar to a multi-firm scheme. And so the existing power was, of course, was the 45 power in the 2000 Act, and life was breathed into it for these purposes by section 404 F7. And the drafting technique by which they do this is contemplates. It says if the authority varies permission or authorization of a person so as to impose requirements, and so on and so forth. And a question which particularly Milady put to my learned friend, and which was then picked up in my Lord's categories of question as to the power, is why the word if. We say that the meaning of this is no more than if the authority chooses to use the section 45 variation power to impose redress. It's a choice that you now actually have, probably created by this very section.
But what confers the choice?
What confers the choice is 404 F7 making plain in what follows in this same subsection that you can use the power for that purpose. If the authority,
as I understand your case, you're saying that this subsection confers a power to establish and operate a scheme corresponding or similar to.
indeed.
Not just conferring a power to do the things, for example, in A and B. You rely on the first 3 lines or so.
Milady, yes,
To
it creates
create
that, but
that
the technique it
power.
uses is to create the power through section 45 as it then was. So it's not creating an entirely self-standing power, because it says if the FCA varies a permission or authorization of a person, that power to vary a permission or authorization of a person is the power in section 45 as it then was, now section 55L.
I have to ask why Parliamentary Council didn't just say the power in section 45 includes a power to establish.
Well, Lady, I accept that the drafting technique is perhaps not the most natural, but we say that absolutely that from all the analysis of the way the power developed, that must have been the way it was chosen to be done. I accept your ladyship's point. There are a number of ways it could have been drafted, but the way it is done is to include in the same subsection, as it were, both you have this power using the section 45 power to do this, and also if you choose to do it, these are the requirements that you have to impose, or can, if you're choosing to go down this route, that you must impose.
So the power to do this did exist under section 45.
No, my lord, we say that, no, we say that until this subsection clarifying the position came along, the power in section 45 was not clear or broad enough to enable, to permit the power.
But
to
I
be
had understood that
exercised.
to be your case, but your answer to my lady as to where was the choice conferred
Yes.
was to say it was already conferred in section 45.
No, my lord, sorry, if I said that, I apologise.
Well,
I'm misleading.
that's how I'd understood your answer.
What
I'm
I'm
just querying
effectively
it.
saying is that this provision breathes life into a pre-existing power which could vary permission or authorization of a person.
Okay,
But until this section, it couldn't be used to do it to impose a past redress scheme.
And I think it's part of your argument that the extent of the life that's breathed in is restricted by reference to the words corresponds to or is similar.
Precisely, and
So
indeed,
so you can't. I think that's a necessary part of your argument, isn't it?
that isn't necessarily probably. It's also confined and operatively, perhaps even more importantly, confined by includes a provision imposing requirements on the person corresponding to those that could be included in rules made under section 404. Because the rules made under section 404 are 404A, and that is the gateway into all the section 404A limitations.
So you say that A provides a limit as well as the reference to corresponds or similar in the second line.
Indeed.
And that's despite the fact that A and B are introduced by the word includes.
Indeed. Despite that, the sense of this subsection, we say, if I can paraphrase, it is if the authority chooses to exercise the section 45 power to vary permission to impose requirements amounting to a single company redress scheme, the provisions that it may, i.e. is permitted to, include in the varied permission are A, provisions imposing requirements corresponding to permissions that could be imposed on a multi-firm scheme, and B, provisions corresponding to 404B. If you want to do it, this is how you ought to do it, and that fits in with corresponding to or similar to a multi-redress scheme, because by the legislative means in subsection A of the provisions imposing requirements, that effectively makes the scheme one which corresponds to or is similar to a consumer redress scheme. Not identical, because you haven't got to prove the many firms who are failing it and so on and so forth, and whatever other differences there are. But the technique is not simply to say, well, it's got to look rather like it in the main body of subsection 7, but to actually stipulate that the requirements you can impose on a person have to correspond to those that could be included in rules made under section 404.
Well, yes, but effectively you're reading it as if it said the FCA may vary permission so as to impose requirements, and if it does so, the provision that may be included are limited to the following.
Yes.
Which does require two distortions of the text. One is changing if you vary to you may vary, and one changing the word includes to is limited to.
Lord, I don't accept that either of those are substantial distortions. I accept that they are not. They're
infelicities.
They are. I'd accept their infelicities. If my lord, it isn't necessarily. Because of course you can still vary permission and authorization for all sorts of other reasons. So it's hardly surprising that they said if you vary, because if you're doing a variation for this particular purpose that follows, for the purpose of imposing requirements to operate a scheme.
It is slightly surprising if you're right that from 2000 to 2010 there wasn't any power to vary a permission so as to impose requirements.
Yes.
Because if, as my lady said, effectively, what you're wanting it to mean is you may now, for the first time, vary a permission so as to impose requirements. And if you do it,
yes.
this is what happens.
Well, it's possible that this wording, and this is total speculation on my part, it is possible that this wording was arrived at because persons looking at the earlier act saying we want a single company scheme, power scheme, do we have one? looking at this earlier section, well, do we or not? It's not very clear. On the one hand, we're not very, going through all the arguments I went through with the court on section 45, you end up in a position, perhaps, of some uncertainty as to whether there was a pre-existing power. We would say not, but you can see how...
I would have thought if you were uncertain whether the power existed, we all the more reason of saying, for the avoidance of doubt, you may now do it this way, but if you do it, you have to do X.
Well, Lord, I respectfully suggest that if there was any doubt, then using the formula, if you want to vary permission to do all of this, this is how you do it, is not a perhaps a less surprising legislative technique than if you were simply bolting on a new power that didn't exist before. If this was, let's create a new power, this would be a more surprising, perhaps a more surprising way of choosing to do it than if perhaps there was someone said they did. Certainly the legislature didn't want to admit that there hadn't been a power up to now. On the other hand, it didn't want to potentially compromise the section by saying that there was a power. So it might be, I can, pure speculation, that is why what I accept on the face of it looks like a slightly unusual use of words. But we do say that far more important than the difficulties one has to get over in looking at words like if and include are the overall analysis. The overwhelming indications of this section are that what it was doing was creating a power which, or constituting a power, if one wants to use a less contentious term, which tracked the multi-company scheme and did so specifically in relation to the four conditions through subsection A, keying into the 4A rules. It is any other conclusion for a number of reasons which I'm going to come on to, either make section 447 completely OTOs on the case that the whole thing existed perfectly formed ever since 2000 in 55L, makes it equally inexplicable as to why you would have a section with this strange wording even if 55L existed all along. In a sense, the challenges of the section in terms of its wording are challenges you could equally put to Mr. George when he's explaining to you why it's a clarificatory provision. Can I deal with one or two threshold objections, which I can hopefully dispose of quickly? This is not a case about implying things into a clear power, as my learned friend suggests in paragraphs 19.1 to 19.3 of his skeleton. It's not an implication at all. We're engaged in statutory construction of what are on their face interlinked provisions. So the citation of Woodovitz at paragraph 19.4 we just say is inapposite. Furthermore, our interpretation does not seek to limit one broad power, 55L, conferred under one provision by reference to a more specific power created under a different provision of the Act, which the authority objects would be contrary to section 415A. I'm not going to go back to that provision. On its face, on Leonard Friend's case, it doesn't defend that principle because he says 404 F7 doesn't have any power in terms of imposing a scheme. So this is not an exercise of saying, well, because you have a specific power, you haven't got a more general power. These are two interlinked powers, and was engaging in a statutory construction exercise of how they relate. 404 F7, we acknowledge, is not a freestanding power at all. It's integral to creating and addressing how and to what extent section 45, section 55L has life in this area. Lord and Lady, can I turn to a number of factors which we say support our interpretation of the redress scheme? They're all in our skeleton from paragraph 34 and following, and I'm going to pass over some of them in the interest of time because this case has a horrible effect of eating up time. One finds one is behind, or at least I do. I should confine that to myself because Mr. George was bang on time. But the first of the seven factors the court already has, the unprecedented breadth of the power itself, is a factor which we say the tribunal rightly took into account at paragraph 280 and 283 of seeking to avoid a construction which would produce a surprising result, which ought to be avoided if possible to avert unreasonable or absurd results. And we do not shrink from saying that Leonard Friend's construction fits within that description. and we'll come on to that further in relation to the human rights arguments, but it's an argument, it is an appropriate and engaged aid to construction in this case. Secondly, the tribunal was right to find that the authority's construction would lead to a striking anomaly with the multi-firm scheme. That's between paragraph 287 and paragraph 311. I've made those points. I won't say more about it. What I should address shortly is the authorities' attempt to explain or justify the anomaly between the multi-firm scheme and the single-firm scheme. Paragraph 30.1 of their skeleton, it is suggested that Parliament could have intended such a divergence in the statutory conditions because a multiple firm scheme is capable of binding a number of different economic actors within a particular market and has the potential to have a substantial impact on the industry or UK economy as a whole. And those risks are unlikely to arise in the exercise of a Section 55L power in respect of a single firm. Because we say that justification doesn't begin to explain the particular disparity of treatment which on their case arises. The first point is simply there's nothing in the legislation or in the legislative background to suggest that such a distinction was justifying a difference in treatment. It's pure speculation. But secondly, and more fundamentally, we say that as an explanation, it just doesn't stand up to scrutiny. Multiple schemes are unlikely ordinarily or in the usual course to have a substantial impact on the UK economy or on industry. They could do, but it's certainly not a necessary condition of them. It's inherently unlikely that the more demanding triggers were imposed on all multi-firm schemes for that reason. But in any event, and perhaps more fundamentally, the difference in treatment, the more demanding triggers, one would expect them to be rationally linked to the anticipated impact on industry or the UK economy, possibly in the form of a heightened test for imposition in some specific circumstances, for example. But in fact, the more demanding triggers, the establishment of breach, causation, loss, and so on, are merely the ordinary incidents, we say, of requiring redress. They're not the sort of legislative response to a concern that in some cases, multi-firm schemes might have wider economic impacts that would need catering for. They're more merely ordinary incidents of redress. They're nothing to do with and don't address any such concern. So we say that even on its own terms, it's an implausible explanation to justify the distinction. Thirdly, my lord, my lady, we do say that if the authority was right, that it had an almost unfettered power under Section 55L ever since 2000, there would have been no need for Parliament to introduce Section 404 F7 at all. It would be, as the tribunal noted at paragraph 293, redundant. And at paragraph 297, the Upper Tribunal rightly rejected the authority's attempt, raised again on this appeal, skeleton paragraph 27.3, to breathe some form of independent life into Section 404 F7A by way of discerning provisions permitting the imposition of requirements on firms that would not be available on their case absent the provision.
Well, the one you singled out was the ability under little m to make a liability to pay a debt.
Yes, that was one, and then much bigger, and then more and more eggs were placed in this basket as time went by, was the FOS under B.
Yes, but that's B, but I thought you were addressing A.
I'm going to address both, but indeed, A, the first point is A. I apologise.
But I was just wondering, this point about turning a liability to pay into a debt, I mean, is there not something in that I can see that if a regulator has power to make a regulated person pay X money and doesn't pay, it's not automatically obvious that X can sue for the money.
Well, one wouldn't need to go that far. One could simply, on Malone Friend's case, as part of your exercise of Section 55L, include a requirement in the varied permission for the firm to enter into a contract with by deed, for example, with any customer in respect of who was found to require redress after the process had been gone through. I mean, the enforcement mechanism could be achieved using Section 55L if it was thought there was a need to do so. Most firms, there probably wouldn't be thought because if they're ongoing ongoing firms with ongoing permission, the regulator will be astute to ensure they're complying with their remedial obligations, and there could be dire consequences if they don't. So I think we're dealing with a fairly unlikely example. But the point which my Lord Justice Popplewell made when my learned friend raised this point, and we respectfully agree with, is that there's no difficulty in seeing how, if it was thought necessary, the regulator could have used Section 55L to ensure that there was effectively a self-executing mechanism by way of the variation of permission. Obviously, contract I say under deed because there might be no consideration for it. So one.
But also, you can't force someone to enter into a bilateral contract. It would require the consumer to also contract. But you're right, you could
do it by deed. Yeah.
You could do it by deed poll. Yes.
So look, it's a pretty unlikely example, but we say there's absolutely nothing in the suggestion that even that one provision, subsection M, of all the long list, which is the only one my learned friends picked out of, has any explanatory power at all. So we do say that your Lordship is right to restrain me and to take it by steps. We say that first of all, Section 1A is OTOs. We also, and as time went by, learned friends, as I say, put more and more eggs in the FOS basket. That, of course, doesn't answer the question that A would still be OTOs. But also, even on its own terms, we don't think that his FOS explanation works either. I should say that learned friend relied on the FOS example not only, I'm dealing with two arguments, not only to show that the power wasn't OTOs, but he also relied on it as the explanation for all sorts of uncomfortable references to Section 404 F7 in the authority's own guidance, continuing up to today's guidance, and in post-legislative provisions. In all cases where 404 F7 was mentioned as a power or origin of power, he said, well, it might be needed for the FOS example. So it's an important explanation on his case. We don't see that it works even as an explanation. If one looks again,
just before you embark on this, will that be a convenient moment to break? Do you think? Given we're going to have a shorter lunch. We'll come back at 1:30, please.
All rise if able.